But I would ask you to just expound a little bit on why you think then that Allen versus Milligan is relevant, or the fact that we held or what we held in that case is relevant to what we're doing here today.
Allen versus Milligan is a nearly identical case. There was a similar challenge where we won on a preliminary injunction that there was a Section 2 violation because the state of Alabama in that case cracked and packed the black community, cracked the black belt. And ultimately, this court found that that was a clear violation of Section 2. Similarly, what we have in Louisiana is a circumstance where Louisiana was constructing a map and had a single district that could elect a preferred black candidate and had an opportunity to draw a second district based on the size and geography of its black population, and chose not to do so in the face of 7 illustrative maps that made clear that they were not dilutive.
And what we in part were considering in the context of Milligan was whether or not to change the Section 2 criteria, the Jingles criteria. Is that your understanding?
That's right. The state of Alabama,
and we chose not to.
The court was very clear about that.
And so the parties, I took your initial starting with Milligan to be a suggestion that we not revisit the determination that we made just 2 years ago that the Jingles test not be revised.
That is absolutely correct. And in fact, appellees on page 11 of their supplemental brief state that they understand that this court answered that question clearly, that results is a constitutional test, that race can be used to remedy violations, and it therefore isn't making that particular argument. In fact, even the SG acknowledged that race can be used in a remedial form when necessary. So those questions have been asked and answered by this court in Allen versus Milligan, and some parties here recognize that those are closed questions.
Can I ask you a question